Even if there has been a breach of contract, and even if there has been damages as a result of the breach of contract, there may be affirmative defenses available. And if you'll recall, in a previous unit, we talked about affirmative defenses, and that's a situation where the defendant in a lawsuit says, yes, I did everything you said, but there was a reason I did it, and it's a reason that the law recognizes as a defense. So what we're going to talk about right now is what are the available affirmative defenses to a breach of contract action. One of them is duress. So I signed this contract, I agreed to this contract, but I did it under duress. There was a threat, and somehow I was induced to sign this contract through some sort of, you put a gun to my head, or you blackmailed me, or something like that. And so, yes, I signed the contract, but it wasn't really a meeting of the minds because it was under duress. Another variation of that would be undue influence. So this is a situation where somehow there's a relationship of dominance, and one party has very strong influence over the other. Maybe because there exists a fiduciary relationship, or one party's in a weakened state, and the other party induces them. Maybe they're elderly, something like that. So you could say there was undue influence. Another one is mistake, and this requires a little bit of explanation. So a contract entered into based on a mistake is potentially a voidable contract. Now, a mistake is an error about a fact that was in existence at the time the contract was made. And there are two types of mistake. You could have a mutual mistake or a unilateral mistake. So if both parties were mistaken, and the mistake concerns a basic assumption on which the contract was made, and it has a material impact on performance, and the party seeking to avoid performance has not assumed the risk of mistakes, then the mistake could potentially void the contract. A unilateral mistake is when one party is mistaken, and there again it has to concern a basic assumption on which the contract was made, and so forth. But there, because it's only one of the parties, the equities really need to favor avoidance of the contract. So it's much more difficult to avoid enforcement, obviously, if one party claims they're mistaken about some of the premises of the contract than if both parties were in error about the contract. Another defense would be misrepresentation or fraud. Misrepresentation is some assertion that's just not in accord with the facts. If as part of the contractual negotiations, I say something that is untrue and that induced you into entering the contract with me, that would be a misrepresentation and potentially a defense to the breach of contract action, assuming it was a material misrepresentation. If it's just something that's, that I happen to say that was in error, but it really wasn't a core part of the contract, then it probably wouldn't be good enough. Then, of course, there's fraud. Fraud is a misrepresentation made with intent, and that obviously would void the contract. But remember, in order to prove fraud, you have to prove intent, which is known as scienter. You have to prove that what was in my head was deliberately trying to induce you into entering this contract under false pretenses. It wasn't a mere misrepresentation, a mere error. It was actually fraudulent. Another defense is unconscionability. The idea of unconscionability is, yes, we signed the contract, but it is the type of contract where it would be shocking to the conscience of the court and of the society to enforce such a contract. For example, the terms of the agreement might be grossly unfair or unduly favorable to one side. And that's particularly comes up in situations where the parties have unequal bargaining power, and one party insists on a take-it-or-leave-it basis that you agree to these incredibly onerous terms, and you don't really have any power to bargain, and so you sign them. A court might say that that was an unconscionable contract. It also might be that the type of contract itself is unconscionable. So a slavery contract or a contract to sell body parts or something like that might also be an unconscionable contract. And the final affirmative defense is the statute of limitations. Many legal provisions that allow someone to sue, whether it's for a tort, a harm that befalls them, or a breach of contract, have a statute of limitations provision, meaning you have to bring the suit within a certain period of time. And the idea here is we don't want you to sit on your claim for years and years and years and then bring it, because first of all, the evidence is very difficult to find at that point, and second of all, there's a value in allowing people what's known as repose. We can now close the books. We know we're not going to be sued about something that happened over a certain number of years ago. And the statute of limitations for contracts can vary by state, but it's usually 6 years. Under the Uniform Commercial Code, it's 4 years. And once the statute of limitations has expired, the contract action is simply barred by operation of law. Now, it's possible sometimes that you could have an exception where you say the statute of limitations shouldn't have started running immediately for various reasons, but in general, the statute of limitations is a complete bar to recovery.